Right, good morning, everybody, and welcome to the first employment law update for VWV this year. Happy New Year, if we're still allowed to say that very nicely. So I will start off. So if we move on to the first slide, it's just an overview saying what we'll cover. So first is the case law update, which I'll be dealing with, and then Alice will cover some information about preparing for April 2025 and the latest on the dreaded Employment Rights Bill. And then finally, as I say, we'll do question and answers from any questions you've put in the Q&A box. So moving on to the first slide of the case law update. The first case is the case of Haydock versus ADP RPO UK Limited. And this is a case all about redundancy consultation in small scale redundancies in non-unionized workforces. Small scale means where the statutory rules around collective consultation do not apply, so fewer than 20 redundancies within 90 days. The key facts of the case are that the employer decided to reduce its workforce and carried out scoring against selection criteria before starting consultation. Mr. Haycock scored the lowest. It then held 3 separate individual consultation meetings, all those in the pool of selection, not just Mr. Haycock. At the end of the consultation period, it informed Mr. Haycock that he was redundant. The first time Mr. Haycock was given his individual score was after the decision to dismiss had been taken. Mr. Haycock appealed against the decision to make him redundant, and ADP carried out what the tribunal later described as a thorough appeal process. Mr. Haycock then brought an unfair dismissal claim, and the Employment Tribunal decided that his dismissal was fair. Although Mr. Haycock's redundancy scores were not disclosed during the initial consultation, this was remedied on the appeal process, which was deemed to be thorough, and Mr. Haycock was unable to prove that his score was unfairly low or that the selection criteria were flawed. Mr. Haycock then appealed to the EAT, and his appeal was successful. The EAT found that meaningful consultation had not occurred early enough in the redundancy process. Importantly, the EAT commented that good industrial relations practice could entail workforce-wide engagement before individual consultation meetings, regardless of the scale of the redundancies. This led to uncertainty about whether general workforce-wide consultation was expected for small-scale redundancy processes, just as it is for larger collective redundancy processes. Many thought the EAT was suggesting that a fair redundancy consultation must include workforce level meetings before individual meetings took place. ADP then appealed to the Court of Appeal, which held that in cases like this, there is no requirement for workforce level consultation meetings before individual meetings take place. In effect, the Court of Appeal was restoring the status quo. So what are the key practical points arising out of it? So the first one, which I've already highlighted, is that general workforce consultation is not mandatory in small-scale redundancy consultations, although it could be helpful depending on the facts of the case. Second point is that individual consultation ought to cover issues common to the workforce, as well as issues particular to the individual. So the Court of Appeal suggested that issues common to the workforce would be ways of avoiding or reducing redundancies or mitigating the effect of redundancies, and gave the examples of issues particular to the individual as being their own scores or suitable alternative employment. The third point to note is that consultation ought to take place at a formative stage, whilst the decision maker remains open-minded, and comments and suggestions made by employees may influence the outcome. The Court of Appeal pointed out that the later the consultation takes place, the greater the risk the decision maker will have closed their mind to the consultation, and the consultation will be meaningless. The fourth point is that ideally scoring should take place after the consultation process has commenced and employees have been given the opportunity to comment on the selection criteria. However, a failure to do so will not inevitably result in the redundancy process being unfair, provided that the employer remained open during the consultation process to being persuaded that their choice of criteria was wrong, or that the scoring exercise was done by the wrong person, or on the basis of inadequate information. The fifth point is that employees ought to be given their own scores during the consultation process and an opportunity to comment on them. And the final point the Court of Appeal made was that procedural unfairness in a decision to dismiss can be cured by a fair internal appeal. But of course, it would be better not to have to rely on that if at all possible. So moving on to the next case of Carozzi, I hope I'm saying that right, versus the University of Hertfordshire. This is a case all about harassment. So just taking a quick step back, under the Equality Act, harassment is defined as follows. A person A harasses another person B if A engages in unwanted conduct related to a protected characteristic, which has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. In deciding whether conduct should be regarded as having that effect, a tribunal must take into account B's perception, the other circumstances of the case, and whether it is reasonable for the conduct to have that effect. Ms. Carozzi is a Brazilian national of Jewish ethnic origin. She alleged comments about her accent amounted to harassment as they related to her race and fulfilled the other elements of the test under the Equality Act. The Employment Tribunal dismissed the claims, finding that the comments were not related to her race. Instead, the tribunal found that the comments had been about Ms. Carozzi's comprehensibility when communicating an issue which was not connected to a particular race or ethnic origin. Ms. Carozzi appealed, and the EAT overturned the decision, making it clear that harassment can occur where the protected characteristic in question did not motivate the harasser. On the facts of this case, it was possible that Ms. Carozzi's accent was an important part of her national or ethnic identity. As such, comments about her accent could be related to the protected characteristic of race. So on that basis, the EAT remitted the case to a new tribunal to consider the issue again. Now, this doesn't mean that any mention of a person's accent will amount to harassment. Each case will be fact-specific, and tribunals will have to consider all elements of the test, including whether there is objectively some relationship between the conduct or language used and the protected characteristic, whether the conduct was unwanted, the perception of the claimant, and whether it was reasonable for the conduct to have the effect of violating the claimant's dignity. The important practical point about this case is that it highlights the broad scope of the harassment laws under the Equality Act. Comments about personal traits, such as an employee's accent, can constitute harassment if they relate to a protected characteristic, even without discriminatory intent. In terms of action points, this approach needs to be reflected in equality and diversity policies and in staff training. So moving ahead to the next case, which is Johnson versus GT Get Taxi. And this is one in a long line of cases about worker status in the gig economy. And the first thing it's important to note is that all of these cases turn on their own particular facts. Taking a step back again, I thought it might be helpful to run through the statutory test for worker status in the Employment Rights Act, the test most commonly applied in the workplace. So, assuming that full employment status is off the table, so we're just looking at situations where someone's status is uncertain, if a tribunal is asked to determine whether someone is a worker, The starting point will determine whether or not there is a contract between the potential worker and the potential employer. This is where tribunals consider concepts like mutuality of obligation, irreducible minimum levels of obligation between the parties, and whether there's an umbrella contract in place. Increasingly, cases focus on whether there is a contract in place while the individual is providing their services, rather than focusing on periods of inactivity between particular jobs, meaning that this element of the test is often satisfied. If there is a contract between the parties, the tribunal will then consider whether there is a requirement for personal service. When considering this part, the tribunals will often consider the issue of substitution. If there is a contract in place and personal service, the tribunal will consider whether the individual was carrying on a profession or business undertaking, making the potential employer a customer or a client. If this is the case, the individual will not be a worker. Concepts of subordination, control, and integration are relevant to this test, this part of the test. So looking at Mr. Johnson's case, as it says on the slide, he was a black cab driver who used the Get Taxi app to secure bookings. This generated around 5% of his earnings. When the dispute arose around his status, there was no real question that he had a contract with Get Taxi and provided personal service. However, he was not seen as a worker because Get Taxi had limited control over drivers using its app. You can see examples of this on the slide. So the bullet points there talk about the autonomy he had to decline rides, to set routes, and to use other platforms. The limited reliance he had upon the Get Taxi app, and the fact that Get Taxi didn't impose a great deal of control. Any control over his actions stemmed from the Transport for London rules rather than any rules provided by Get Taxi. All of this meant that Mr. Johnson operated as an independent business and was not a worker. As it says on the slide, this can be contrasted with the Uber case, where Uber was seen to exercise significant control over the users of its app when they were logged into the app. As a final point, Mr. Johnson's case stemmed out of whistleblowing legislation, and it's worth noting that the definition of worker in whistleblowing cases is wider than the usual definition. It also includes agency workers, home workers, police officers, various medical posts within the NHS, and certain people undertaking training or work experience otherwise than part of an educational course. So moving on to Hunter versus Carnival on the next slide, which is the last case we're going to look at. This is all about when Regulation 10 of the Maternity and Parental Leave Regulations applies. So as you probably know, Regulation 10 provides redundancy protection to employees who are pregnant or are on maternity leave, adoption, or shared parental leave. If a redundancy situation arises during the period of protection, the protected employee must be given priority in the allocation of suitable alternative employment. Prior to April last year, this protection lasted during the employee's leave and ended on their return to work. From April last year onwards, the scope of the protection was extended so that the protection now applies from the date the employee notifies the employer of a pregnancy and lasts for 18 months following the child's expected week of birth or adoption. If an employer fails to comply with the duty, any redundancy will be automatically unfair. The key facts of the Hunter case are on the slide. So she was a team leader on maternity leave and was one of 6 team leaders who were made redundant. The remaining 16 team leaders remained in post. The employee argued that the remaining 16 team leader roles should have been offered to her as suitable alternatives in employment. The Employment Tribunal agreed, finding that the roles were suitable alternative vacancies, and that failing to offer them was automatically unfair dismissal. the employer appealed and the EAT allowed the appeal, holding that for Regulation 10 protection to apply, there must be an actual vacancy. In this case, there were no genuine vacancies, as all the roles were filled. Therefore, Regulation 10 protection did not apply. And the key takeaway from this case is to think carefully about whether there is a genuine unfilled vacancy before applying the protection afforded by Regulation 10, rather than jumping from the fact that someone is on maternity leave to giving them preference over roles in cases where where Regulation 10 might not apply. Okay, so that is the final case I'm going to look at. I'm now going to hand over to Alice, who'll take you forward from there.
Thanks very much, Michael. Yeah, we thought it would be helpful to use this moment, the first webinar of 2025, to look at some of the changes that you will need to plan for over the coming year. It's likely to be another busy year, I think, for HR professionals. On an ongoing basis. So we wanted to start with some of the changes that we're going to see in April. The first one that you'll see on the slide is the annual national minimum wage increase. I'm not going to read the figures. You'll have a copy of the slide, so you'll see the uplift that's applying from April this year. You will obviously need to factor that into your budgets. There are a couple of interesting questions or issues that always flow out of it. Perhaps this year the most interesting point is the significant jump in the bracket for those who are aged 18 to 20, going up to £10 an hour. And this represents a commitment to ultimately remove that particular age bracket so that all employees age 18 or above will be entitled to the same national living wage rate. So at the moment there's a phasing in so that the differential is being reduced, so that there will then be it will catch up, and they will just simply be in the what is currently the 21 plus group is the overall intention. Generally, it's another strong commitment to the living wage and quite a significant increase across all the bands. The government has absolutely committed to try and track inflation, although I saw today that inflation's dropped, but to ensure that the minimum wage is always tracking inflation, and also to get it to a point where it's 2/3 of the average median earnings as well. So it continues to demonstrate an increase. We do still see every year HMRC challenging employers who are not paying the minimum wage appropriately. Often that's technical breaches, so sometimes that's about not getting your pay arrangements in place in good enough time. It's particularly tricky, and I know on this webinar we've got quite a few people who are in educational and other establishments who may not have a financial year that aligns with the April uplift. That always creates difficulties, and decisions around, do you do a part uplift now, do you then sweep it up in September? But you will need to make sure you at least identified those who will fall below the new rates. There are also questions, of course, around people who are paid just above the living wage, and because we're seeing such strong increases, those additional differentials are being reduced, and there's no legal obligation at all to maintain differentials for other members of staff, but obviously it's something you may want to do due to recruitment and retention requirements, or just more generally to consider having a clear pay structure. But that's definitely something it's worth looking at and thinking about, given the increases that we're seeing. The second half of the slide relates to another staffing budgetary increase, which is the increase we saw announced in the budget, which hadn't been expected, to employer national insurance contributions. I'm sure you'll all be aware of this, but essentially we're seeing a rise in the employer rate from 13.8% up to 15%. Not only, I think the feedback we've had from lots of clients is that not only is that rise causing an impact, it is actually second element of change that's causing the most significant cost increase, which is that the threshold for when employer national insurance payments are due has dropped significantly. So that lower earnings limit is going down from £9,100 to £5,000 per annum. So what we're seeing is significantly more staff are swept into that, and so there'll be an increased employer national insurance bill. We're already seeing the impact of that. Lots and lots of our clients are looking at ways of reducing staffing, ensuring that staffing structures are as efficient as possible, and looking at staffing overhead, given the combination of these increases that we're going to see in April. The next change that I wanted to talk about is one that's been actually bouncing around since April 2020. In fact, it was first introduced, and then we've had an act, but it's never made it across onto the statute books. But we now anticipate that this is going to turn into regulations and be implemented in April 2025. And this relates to the right for parents to have neonatal leave and pay. We're still awaiting some regulations, so some of the detail is yet to be finalised. But essentially, this gives an additional right to parents where their newly born child has to have some form of neonatal, medical or palliative care within the first 28 days of their birth. That has to be for at least a continuous period of 7 days or more, and then that will trigger this entitlement. And the intention was that where those babies are born often prematurely or in need of medical assistance in those early days of their life, that actually the current rights, particularly to paternity leave, were quickly absorbed before babies even come home. And fathers in particular, but partners were having to use unpaid leave, sometimes compassionate leave, sometimes taking sick leave to try and provide support or spend time with their newborn, and it's to address that issue. So where those eligibility requirements are met, then there'll be a right to some additional leave. It seems likely that that leave entitlement will mirror the amount of time that's spent in neonatal care, so from 1 week up to probably a maximum of 12 weeks. And that can be added on to existing leave rights. So potentially to the end of maternity leave or paternity leave or shared parental leave as well. So it's an additional right. Everyone who meets the requirements will be entitled to it. So there's no qualifying service requirement, but it will only be paid where individuals have got 6 months service 15 weeks before the expected week of childbirth or the neonatal care kicks in. So there's a 6-month qualifying requirement still to be paid, and it's likely that pay will be based on average normal earnings for that period of leave as well. The notice requirements as well, there's going to be probably an informal notice. So initially, if you need to go into hospital to look after your child, that you'll just be able to informally let your employer know. But then there'll be a more formal notice requirement at a later date to invoke it, particularly if it's been tagged on to the end of some more formal leave. So that's likely to be how it works. But as I say, we are waiting for some regulations that are going to provide a bit more detail. But it is another change that you'll need to keep an eye on, and will need to update your policies and be aware of, and make your staff aware where there are newborns who are born with care needs that meet those requirements. As Michael said, we couldn't do an employment update 2025 without talking about the Employment Rights Bill. And I've essentially got 2 slides. I've got a slide of changes we think will happen, and one where they're much less likely to happen, but we thought it was really useful to share those with you because we see so much press and media attention about these different changes, and we are going to help track some of these through. as you'll be aware, the Employment Rights Bill is a really significant piece of legislation that came that was published on the 10th of October, just before Labour had got their first 100 days in power. We then have seen on the 27th of November, so not long before Christmas, you may have missed it, a paper amending, making some amendments to clarify or to sweep up some other points that had come out. It is now at committee stage, and so is being debated through the parliamentary process, but we thought it was useful to look at those amendments, and I'll reference back to some of the Employment Bill changes where that's appropriate. So the first proposed amendment, which is mooted, is that employees will have an extended period of time to bring an employment tribunal claim. So you're probably aware that at the moment, for most claims, the process needs to be commenced within 3 months of the act or the dismissal. If it's an unfair dismissal claim, it's slightly more complicated in that the action that they need to take is to contact ACAS for the pre-claim conciliation process. But it's likely that for all claims we'll see an extended 6-month period, and that may be extended a little bit further if then the ACAS process is added on. It's a bit of a nuisance because I think we all like to feel that when a situation has been difficult, that we know whether the risk has passed when we get to that point, so it will extend that period of time. You will also have seen in the Employment Rights Bill, one of the most significant changes that was heralded is this idea that all employees will have protection from unfair dismissal from day one, that there won't be the 2 years qualifying service. That's a change we're likely to see in October 2026. So there's been some further discussion around what that will look like. It's likely to be what that will look like, and there's likely to be an exemption where somebody is in their initial period of employment. That's likely to be a 9-month period, and during that time you will still be able to bring their employment to an end following a shortened process, and we're waiting to see more details about what that process looks like and so how it will apply in practice. But there's also a suggestion, which is quite useful, that where an employee is dismissed during that initial period of employment, if you haven't followed the process, and so there may be an unfair dismissal claim, that actually the compensation will be limited. So that will be a useful thing if that happens, because we'll have greater ability to manage risks in the early days of somebody's employment during that initial period. One of the other changes from the Employment Rights Bill is around 0 hours contracts. I think it's probably my least favourite part of the Employment Rights Bill. It's incredibly complicated, and the government is essentially trying to ensure that employers can use 0 hour contracts where it's necessary and helpful, that both parties want it and it's useful to meet business need, but they're not exploitative, and looking at ways to manage that. And so there's a right to request guaranteed hours for certain 0 hours or low-houred workers. And the amendment that is being proposed is that there will also be a positive duty to let those employees who are protected under these provisions know about their rights and know that they've got a right to request that guaranteed hour contract. So I think it is an area that requires a bit more work and a bit more thought, which we will hopefully see before it comes, before it hits the statute books. But there is clearly going to be a need to audit your organisations to look at the individuals who are going to be recruited on 0 hour or low hour contracts who are protected by this, be aware of the rights that protect them, but also this positive duty to let them know and include that in their contractual documentation as well. The fourth bullet point on this slide, which is the amendments proposed to add on to the Employment Rights Bill, relates to public sector outsourcing. Again, I know we've got some public sector bodies on this call. This actually reinstates a Labour Party code that was in place and that was repealed by the coalition government, actually. And the intention is that where an organisation contracts with public sector bodies and is carrying out some of the functions of those public sector bodies, there's quite a lot of protection in place already for workers, employees who transfer over to carry out those duties whilst working for the public sector body. While working for the private sector body. If they come out of the public sector, they transfer over under GP to work for the private sector, and they're protected. And so this code is essentially about a two-tier workforce code, is to prevent those private sector employers from recruiting their own staff on lower terms and conditions, less favourable terms and conditions than the ones that they've got that have come out of the public sector. So it would mean that it's much more costly potentially for employers to contract with and carry out work that had been public sector work. So it's likely to limit public sector outsourcing. So if you're an organisation that does lots of work and contracts with the public sector, it's something you would need to think about. And equally, if you're a public sector organisation, it will increase the costs of contracting out as well, probably, and make it perhaps less commercial to do that. The next point that got picked up in these amendments relates to trade union access. Those of you who are tracking the Employment Rights Bill will know that one of the areas of focus is to empower trade unions and give trade unions right to access the premises. And this of employers, and this is rights to access where trade unions are recognised, but where they're not, critically where they're not recognised. So all trade unions would have the right to access the premises, to essentially talk a bit more about their services, to recruit members, to support employees, and employers, as long as their right to access was reasonable, employers would have to agree to that. And if they didn't agree, there's a process to go to the Central Arbitration Committee to agree a right of access agreement. That has been tightened up, but only very slightly, to give that right of access only to certified independent trade unions and not just so they have got to have that certification and be recognised. They've got to be official trade unions in order to have that right. I don't think that minor tweak is going to have a significant impact really on what is quite a broad-ranging right, really, which may change the way employers work with trade unions. And finally, there's a tweak around statutory sick pay. This is really about just extending the provisions to Northern Ireland, so there's consistency across the UK. The change that you may be aware of is to essentially to remove the waiting days so that all employees will have the right to statutory sick pay from day one, and there won't be any days of no pay. And so and to also not have a qualifying earnings limit in order to qualify for statutory sick pay. They're the main changes really to make it broader, and so they're going to be across the piece. So those additional amendments are likely to get picked up when we see the next iteration of the Employment Rights Bill. We have also seen in the amendment paper some other changes that you may have seen discussed in the press or in other journals, and these are probably less likely to come into force. So I'm not going to spend a huge amount of time on them, but I thought it was really important to just give you the heads up so that you're aware of them. And we've put where they've come from, because most of these come from backbenchers promoting issues and causes, or other parties actually, and certainly where they've come from other parties, I think the chance of them coming to pass is less. So public sector employers have a duty to put equality action plans in place. The top proposal, which is amended, relates to the need to incorporate menstrual support, menstrual health issues in those equality action plans. That's come from a Labour backbencher. Still seems unlikely that we'll see that tweak. The next one is on a topic that's already got a lot of attention. We're already going to see further developments around protection from harassment, and particularly sexual harassment in the workplace, in addition to the ones we saw in October last year. And this proposal is that it will essentially veto or will make void any provision in a non-disclosure of harassment in the workplace. So many of you will be familiar with settlement agreements, which essentially include confidentiality provisions where they essentially stop somebody talking about harassment that they have experienced. That provision would be void. I don't think we'll see that in the Employment Rights Bill, but it may come in other ways if the government consider that to be a useful thing of their own volition. The third one is a strange one. Michael talked about the test for workers, and personal service is one of the things that distinguishes employment worker and self-employment. And so often where you're trying to establish that an individual is a genuine self-employed consultant, then there would be a need to substitute and allow them to have substitution. This proposal, I think, is to ensure that that doesn't happen, that for those who are employed or workers or dependent contractors, so not self-employed contractors, and so that those individuals can't be substituted, or they can't be or have the right to substitute, that they must carry out their work personally to create a greater distinction between the two. And finally, the Liberal Democrats are campaigning around extending family leave. We actually thought that the Labour government may more extensively review our family rights, but actually the tweaks in the Employment Rights Bill are only relatively modest and are only really some slight changes, and they're not an overhaul of the current system that's in place. But the Liberal Democrats are pushing for a greater rights, including doubling up the current level of statutory paternity pay, extending paternity leave from the current 2 weeks to 6 weeks, introducing a kinship care leave, and also requiring large employers to publish their parental leave policies and pay, with a view to essentially having an increase in the in those rights. So we wanted to include those so you're aware that they're bouncing around, but I think they're less likely to come into force than the ones on the earlier slide. We are tracking the Employment Rights Bill. There are significant changes going to happen over the next 18 months as a result of that, which will impact on contracts, policies, practices, training, whole range of things that you will need to put in place. And so we will continue to keep you updated as we're getting more detail. We're likely to see the next iteration, I think, of the Employment Rights Bill before the end of the month. So we'll have a bit more detail again then. That brings us to an end of everything that we wanted to say today. So we're happy to look at the Q&A.
I think the first couple of questions, Alice, are related to points I was covering. So I'll kick off with those, shall I, for a minute? So the first question was in relation to the Haycock case, which I covered at the start, where you say that workforce consultation is not necessarily required in a non-unionised organisation. Is it essential if the organisation is unionised? And if so, to what scale? Well, I think the point there is that in the circumstances of Haycock, which was a non-unionised workplace, and in the circumstances of that particular redundancy process, the Court of Appeal was very clear in saying that there was no requirement for workforce level consultation. If it was a unionised workforce, then obviously you'd have to have regard to the union agreement and any obligations that imposes around consultation with the union first. So that's probably why the Court of Appeal was very careful to talk about non-unionised to make that distinction. But behind that, subject to anything the union agreement says, I think probably where there is a recognised union, there's some fairly old case law now which talks about fairness, including some consultation with that union first, or including that union in the consultation. So not doing so, whilst it won't necessarily mean something is unfair, consultation process is unfair, it may have an impact on that. So I think that's why the Court of Appeal was careful to talk about non-unionised in this case. Alice, have you got anything to add to that one?
Nothing to add, Michael, thanks.
Okay. So going on to the next question. It's again about, well, this one's about the Hunter case around redundancy. Would bumping potentially have applied in redeploying a maternity employee? Well, I don't know about you, Alice, but bumping I find a very difficult thing to conceptualize quite often. I suppose underlying all of it is that bumping is something which some cases have said you should consider, but it's certainly not a requirement. And I think you need to differentiate that from a statutory obligation under Regulation 10, which applies where there is an alternative vacancy, suitable alternative vacancy. In that situation, there's statutory obligation to give preferential access to that vacancy to people who are within the protected period. If there's no vacancy, do you have to give someone on maternity leave sort of preferential access to bumping? I'm not sure that you do, and I would be wary of that. I'd be wary of using bumping generally because it's sometimes seems to me a rather unfair process. Alice, have you got any
Yeah,
views
well,
on that?
I mean, I 100% agree that the statutory provisions don't apply to that situation. I was going to say exactly what you said, that it's important to be really clear when the statutory provision is engaged and when it's not. Generally, you're right that the law, there's case law which says you need to consider bumping, and actually where you think it may be relevant, ensuring that you raise it during the consultation process, I think is really really important. It's rare that it happens. I've had it in a couple of cases where it's definitely felt a reasonable thing to do, where, for example, you've got, a team leader who's essentially doing the job but is slightly higher paid role and has some managerial responsibilities, but just team leadership type ones. If that job is disappearing, I think bumping them into the pool and making reductions there can be a reasonable thing to do. I've got one at the moment where there's two slightly different functions. One of them can be done, on more cost-effective terms and conditions than the other, but actually the idea that everybody's could be considered and they potentially bump down into the lower job if they're doing the slightly more senior job. So occasionally it comes up, but actually definitely in terms of your right maternity, there is no obligation to give them preferential or priority treatment in that scenario, and I think it would be a risky thing to do, that you should treat everybody equally.
Yeah, absolutely. Looking at the next question, it's about the Hunter case again, and the question is whether all team leaders should have had to apply for their roles. I suppose this goes back to the idea that you can structure, you can put forward your restructuring exercise in different ways. There isn't a one size fits all, and there certainly is a possibility where everyone sort of undertakes the same role. You could say that all their roles are at risk and everyone needs to apply. That might be one approach. It's quite often the approach taken where the new roles in the new structure vary slightly to the old roles. So there may be new responsibilities or a different sort of divvy up of responsibilities. So people sort of apply for that. But I don't think that's something you've had to have done. In this case, they took the positions appears to have been that all, 20-something team leaders carried out the same role, and they just reduced the number of team leaders, so those roles didn't change. So a number of them fell out the bottom, but people weren't holding alternative vacancies. There was a just reduced requirement for the number of team leaders. So I think that's a roundabout way of saying I don't think they had to have done that. I think it could have been something, if you knew more about the facts of the case, that they might have considered, but they wouldn't have been obliged to do it. Alice, do you want to add to that?
Yeah, well, only just to say, but the point is obviously that if you've got that pool and you're reducing from 6 to 5 or whatever, then that regulation protection doesn't kick in. But if they did displace all of them and make them apply, and that was a suitable alternative vacancy, then the protection does apply. So it's important to understand the distinction.
Yeah, absolutely. I think
We've
we're
got
moving on to
We're
to
moving
the
on,
slides
and
that
I
you were
would just,
covering.
you'll see me, I'm just flicking the slides, because the next question is about, you may know the answer to this, I think I know, but do help me out, Michael. So the question is about the living wage, and if you've got apprentices, and what happens if you've got an apprentice who's age 18. Now, I think actually I articulated that slightly clumsily, that there will still be the lower rate for those who are apprentices, and so there will be a specific apprentice rate, so which will apply if they're genuinely apprentices, and there's some quite strict provisions around whether they apply, and they apply for specified periods of time. But if they meet those criteria and genuine apprentices, I think then the apprenticeship rate is applicable irrespective of age, so even if they're over 18. But obviously once they complete their apprenticeship, if they're 18 or 19, then they will move, what will be the case is that they will get the standard living wage rate ultimately, rather than the lower band, which is in place at the moment. Michael, that's correct, isn't it?
Yeah, I think so.
Yeah, I think so. Yeah.
Yeah, yeah.
The next couple of questions were about neonatal leave. I mean, the question is there a benefit in developing a policy based on what we know now? My advice would be to wait, actually, because there's quite a lot of detail in terms of we're not sure quite who's eligible. We think it's going to be the same list of people for parental bereavement leave, but it's not specified. We don't quite know what the notice requirements are going to be. We don't quite know how long a period it will be. There isn't a definition yet of what neonatal care is. So it feels to me that it's a bit premature. Sorry, that's not a pun, but a bit premature to develop a policy. But I would anticipate that we'll have those details in advance of the April change, and then it's far better to have a policy which reflects the regulations. And if you do want to expand on it or have broader definitions or greater rights, then at least you will know that you're doing that and you're making an active choice, rather than having a policy that is slightly misaligned with the statutory requirements. The question is when it will who it will apply to, and apparently there are some organisations who are already giving additional neonatal protection, so it won't apply to, it will only apply, I think, to babies born on or after April 2025. It won't apply retrospectively, so it won't protect people now, even if they may still be on maternity or paternity leave past April 2025. So it's going to be babies who are born after that date. And obviously companies can decide how they support their employees at the moment. And it's generally a mixed bag, isn't it, of giving them, compassionate paid leave or some unpaid leave if they need it, or using other policies if there are any in place. There's one more neonatal one. Yes, it's correct that there won't be a service requirement for eligibility for neonatal leave, but there will be 6 months service requirement for pay. So that's correct. Michael, do you have any other comments on neonatal? Anything you want to add?
I don't think I do, no. I think it's all been covered off there.
Okay.
Yeah.
We've got a couple more on the changes under the Employment Rights Bill. Yes, the question is around the rights to non-recognised trade unions to request access. Oh, it's an interesting question. Will a different non-recognised trade union be able to request access even where there's already a recognised agreement in place that would be representing the workers in question? Oh, Michael, I've not thought about that. I don't think there's any.
Know.
I don't think there's any preclusion. So I
think
that unions will still be able to request access. Now, it's a really good question. If you were to reject it on the basis that you've already got a recognised agreement in place with a different union, that may force them to go to the Central Arbitration Committee for an access agreement. And I suppose it may depend on what they want and why they want it in terms of what's reasonable, but it's a really good question. And
perhaps you could allow access on an ad hoc
yeah,
case by case basis, being careful to make it clear it's not a general right. In certain circumstances it might be seen as reasonable.
Yeah, and there will obviously be a difference, I think, between potentially access to the same workers who are already covered by a recognition agreement, or perhaps access to different elements of the workforce. that are not in the bargaining unit that's covered by the recognition agreement? Oh, I'm really sorry. It's a brilliant question. We'll have to consider that as we get a bit more detail. Michael, the next question is the extension to tribunal time limits and the removal of the 2-year service requirement. Have a few chances. How you think the employment tribunal system will cope?
Well, I think that probably, without sounding too bleak, probably not very well.
No.
I suspect. And we've seen since the pandemic a gradual and ever increasing amount of time it takes to deal with particularly more complicated cases, to the extent now, I'm sure Alice, the same for you, that cases are now being listed in late 2026, multi-day cases. This doesn't really help anyone. The whole point of the employment tribunal was to have litigation dealt with promptly after the events, in order to memories to be fresh and for matters to be put to one side and allow everyone to get on with their lives. And really, that's not happening now. Arguably that might help employers in negotiation, but underneath it all, it's very unsatisfactory. And if there is a greater strain on the system, it's going to make life more complicated. The tribunals are trying to deal with that. There've been hiring of judges, and there's also a streamlining of some decision-making processes. I think you'll find if you go to preliminary hearings now, you get asked whether or not you're happy to have a judge rather than a judge and a panel in many cases, which we need to think about perhaps a bit more in consultation with our clients before we get to those hearings. And also, I think now there's going to be an ever greater emphasis on alternative dispute resolution. And so I've got a case recently that was listed for 8 days, and the judge imposed a dispute resolution hearing a few months before that case is due to happen, once witness statements are done and once the bundle's ready. And we're ordered to provide a sort of selection of key documents and the witness statements, which the judge will read on the day. Won't be the judge dealing with the full hearing, and that judge will then make statements about their view on the merits or otherwise of the case, with the hope of trying to take the full case out of the hearing list several months later. So those sort of things are going to happen more often. Judicial mediation, I think, will be pushed more. But yeah, overall, I don't expect the tribunal system to get any better.
No. I agree. Yes, the next question. Yes, we absolutely will share the slides as well as the recording, but hopefully there'll be a useful reference. The next question, I agree with somebody who's concerned about the loss of the 3 unpaid waiting days for SSP, because it's a really useful tool in terms of managing that short-term ad hoc absence, particularly for new starters and in the probationary period. I agree. I think we will see a greater focus. And so one of the action plan points that coming out of the Employment Rights Bill, I think, will be looking again at your management of absence. What do people need to do in terms of calling in if they're sick at the beginning, how easy or difficult it is for them to do that? What do they need to do when they return in terms of declarations? Do they need return to work interviews? And having, some system of properly recording it and counting triggers so that you're dealing effectively with absence management in the early stage, well, throughout their employment, but particularly in the early stages, will be really relevant. And Michael, I think that that initial stage of initial period of employment where you're able to potentially dismiss employees, so following that light touch procedure, certainly relating to their capability, would include sporadic sickness, absence, I think would apply. I think that's probably right, but obviously you need to be protected. You need to be really careful where there's an underlying reason where you've got Equality Act protection. That's always difficult. But if you've got somebody who's just taken lots of ad hoc absence, I think you could rely on that during that initial period as capability relating to them.
Yeah, I agree.
The next question is a terminology point, and sorry, I perhaps use this interchangeably. What is the difference between the living and the minimum wage? So it used to all be called the national minimum wage, and that's what it came in when it came in 1998. We then saw a rebranding of the rate for those who are 20, for the main rate, those who are currently 21 and above, to be called the national living wage. So particularly unhelpful. But at the moment we have national minimum wage for people who are below 21 and the living wage for above. And that is different than the charitable national living wage rate, which is based on the real living wage. And that's a different non-statutory concept that's a commitment that many employers have agreed to meet.
It's very unhelpful use of language,
It's
isn't it, really?
really irritating, isn't it?
Yeah.
And then the next question, I think our final question, unless anybody's got any in the last minute, is what's going to be the rate for apprentices? And it's on the slide. It's £7.55 per hour from April 2025, but it's on the slides. I think we've gone through all the questions, which is great. Thank you so much. It's always the most interesting bit. Please do share your feedback for today's session, because we do take it into account. And thank you all for attending, and we will have the next one next month, and hope to see you there.
Thanks very much. Bye-bye.
Bye.